The views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
Well, coming up on this edition of Today's Verdict, so you got another speeding ticket. Not good. Well, lucky for you, we at Today's Verdict have you covered with an expert who will give you the ins and outs of traffic court. Next, an unexpected fire can happen at any time. Well, prevention is key to survival. On tonight's show, we will be visited by one of the best trial attorneys in the city, the attorney who was representing the victims of the deadly Bronx fire that occurred in December of last year. And finally, just because you bring and file a lawsuit doesn't mean that you are letting everyone in the courtroom know about your medical history. But just how far do those protections go? Well, let's find out. As you can see, we have much to get to, so let's get started, shall we? Today's Verdict starts right now. All right, hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesch. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also make sure to like us and follow us at Facebook at Today's Verdict and check us out at bronxnet.tv. Well, just like you, I've had my share of speeding tickets. The process of resolving the ticket can take years off your life, or maybe it just feels that way. Well, on set to talk us off the ledge is attorney Martin Crone. Well, Martin, thanks for joining us.
Thank you, David.
All right, is it me, or does it seem like there are more police on the roads looking for the average speeder?
In New York City, I feel that there are more police on the road due to the mayor's Vision Zero.
And by the way, and just before we even get started, when we're talking about speeding and violations, there's a difference between New York City and New York State. Am I correct?
You're correct. In New York State, you can plea bargain, not have a trial, and walk out better than you walked in. For the most part, in New York City, you're going to either be guilty or not guilty after a trial.
All right, so let's get on the road. All right, so we get the flashing lights. Hopefully we're bright enough to pull over, and when there's no chase, we get over to the side, and boom, you meet your police officer. What goes on there, or what maybe can you say to just even prevent that ticket being written? Is there anything?
Pretty much no. You want to be polite, respectful, and all the common sense things like that. Then the question becomes, should I talk to the policeman and tell him things? I would say not, unless there's an emergency. For example, you're allowed to speak on your cell phone if there's an emergency.
Okay.
So if you tell the policeman, I just got a call that my father's in the hospital or my child fell down the steps, you want to point that out, make sure he notes it in his memo book so that when the case comes to trial, it doesn't look as if you're trying to make something up.
Okay, so at this point, the police officer is filling something out. You don't get to see it, obviously. It's going to be the ticket, and they rip off the stub, and they give you the yellow sheet, and you take a look at it. What is supposed to be there that you need to know about, and what isn't there that you can use to fight the ticket?
So as of recently in the city, instead of writing tickets out by hand, the officers are giving handheld machines to fill the ticket out. The only thing that I could think of would be if the date is missing, something like that. But usually everything is there. It's the parking tickets where it's critical that everything be filled out. So a technicality not that like that's not going to help you.
It's not going to really help you.
No.
Okay, so hopefully we have somebody who's smart enough to hire you. They realize that they kind of really want to either make this go away or plead it or do something with it. What do you do when you first meet with a client and you have to deal with a speeding ticket violation?
I will ask about his previous driving record. The reason that's important is if you get either 3 speeding violations or 11 points in 18 months, your license can be suspended or revoked. So that leads to another point, which is you don't want to pay your tickets. Even if you're not going to hire an attorney, you want to go in there and give it a shot on your own because you don't know what's coming down the pike.
Well, but in New York City, though, is it tough to do any kind of negotiation in there or any?
The commissioner's regulations do not allow for negotiation. So again, if you come to me with a traffic ticket, you're either going to be guilty and get a fine and the points, or not guilty, no fine, no points.
Okay, all right, let's get ourselves into the courtroom. And guess who doesn't make it in on that day?
The police
The
officer.
police officer. Everything's done, right? You get to go home. No.
No.
Why not?
Not necessarily. Lots of factors. Why wasn't the policeman there? If it's an excused absence, you're going to have to come back. What's an excused absence? The police officer's in another court testifying. The police officer is making an arrest. The police officer is sick. The police officer has a death in his family. Those are excused absences.
You know, I know on the back of the speeding ticket, there sometimes is a request for a bill of particulars, or you can ask for, I guess, disclosure. Is there anything
Discovery.
you can get? Discovery. What can you get before you even get there?
Nothing. In New York,
It's useless.
In New York City, the commissioner's regulations provide there's no discovery. Now, if you got your speeding ticket out in Southampton, in Albany, you can request
You can.
discovery.
All right, so you're in the courtroom, and you're good to go. Are you bringing witnesses? What are you doing as the attorney for a speeder?
Sure. So as a general rule, I'm not even going to bring a client, because let's suppose the client's charged with 70 and a 50. If the client says, I was doing 50 miles an hour, that's not going to carry the day. If I'm going to win, it's going to be because I've tripped up the policeman.
All right. Now, you plea bargain. You can't. Well, in New York State you can plea bargain, but let's say in New York City you can't. Let's talk about points. People are always so afraid to get points on their license. Does that really affect your insurance rates? Does it affect your ability to be able to do anything else in life? Explain to us a little bit about that.
So in New York State, at 11 points, you're subject to getting your license suspended. So I've had clients who work as representatives for drug companies. They have a company car, and the companies have their own rules whereby if you get 4 points or 6 points, you're out of your job. So it can affect your livelihood.
You know, a lot of people wonder, well, what do other states know that you have these tickets? Let's say I'm now driving in Florida, but I have 6 points on my license in New York. 3 more points, I lose my license, or whatever it is. Does Florida even know what's going on down there?
Florida will know if you have a Florida license. So if you get a New York speeding ticket or whatever ticket, that the conviction will transfer to Florida.
Will all jurisdictions in the United States, or it's just kind of hit or miss?
It's most.
It's most. All right, tips. Let's give some tips to a viewer who's watching right now, wants to make sure they don't get any tickets, they don't get pulled over, or there's an issue. What's the best tip you can give to somebody?
The best tip has to do with your driver's license. So let's suppose you're living in New York, your car's registered in New York, and you move to New Jersey or wherever. You have to notify the Department of Motor Vehicles in New York that you've moved. You have to re-register your car, reinsure your car in New Jersey. If you don't and New York's not notified, you'll be suspended for an insurance lapse.
Okay, and finally, where do we find you?
You find me on the internet at nytrafficlawyer.com.
All right, I'm sure you're going to be getting a lot of calls from some viewers who unfortunately have gotten pulled over. But at this point, we have to take a quick break. But don't worry, we'll be back with more Today's Verdict right after this.
How can I help my daughter with her reading?
Searching for help with Dachshund breeding.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I was trying to show you how Sarah feels every day. Frustrating, isn't it? Redirecting to understood.org.
Join parents and experts at understood.org, a free online resource about learning and attention issues to help your child thrive.
Verdict. I'm your host, David Lesch. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Well, we at Today's Verdict always try and give you great advice. Well, how to prevent a fire in your home or building may be one of the most important topics we have addressed. Well, joining us today to give us some much-needed insight is trial attorney Robert Valensky. Robert, thank you so much for being here.
Thank you for having me, David.
Certainly a tragedy in December of last year. Could tell us a little bit about what transpired on Prospect Avenue in December?
Well, it's not only Prospect, David, but in the last 3 months, there have been 15 people who have died from fires in Bronx County. That's more than the last 10 years combined. And the main reason for that has been the doors to their apartments. New York City requires that your door in a multiple dwelling be self-closing and self-locking. In the Prospect fire, which occurred on December 28th, the woman who came out of the bathroom, her son had started the fire, and we can get into that in a minute, saw that there was a fire in her apartment, picked up her kids, ran out into the hallway. The door to her apartment did not close.
Now, we hear about this all the time. It's mandatory in terms of the landlord in making sure that these particular doors close?
That's correct. The statute goes back to 1917. So even in buildings that were built many, many, many years ago, the law requires that doors to a hallway be self-locking and self-closing. Over time, HPD, unfortunately, has not been inspecting for that. Matter of fact, HPD had a checklist before this fire that did not include that. Subsequent to these fires, HPD has a checklist of what they check for now, and it includes to check for self-locking and self-closing doors.
Right, so even if a fire is started at the fault of maybe of a tenant or somebody, it could have been prevented or at least contained.
It's not about preventing. We can talk about prevention in this fire as well. I have had a fire marshal, retired fire marshal, go back to the building as I've been at the building 3 times myself. Had that fire door in the first floor apartment closed, that fire would have been contained to that apartment, or at least it would have been in that line. But being able that the door stayed open, the fire escaped into the hallway. It ignited substances on the wall and in the hallway, and that caused tremendous smoke inhalation, causing 13 people to die in that building.
To lose their lives. All right,
Correct.
before we look at the doors themselves and talk a little bit about that, let's talk about fire prevention generally, because there are many people who are watching right now who are probably a little afraid, certainly when they go to sleep at night and wondering if they could be a victim of a fire. What are the types of things a viewer should know to make sure that this doesn't necessarily happen to them?
Well, let's talk about this particular fire first.
Right, sure.
So this fire was started because the 3-year-old in apartment number 3 on the first floor had a history of being able to turn on the stove. So when his mother went to take a shower, he went and turned on the stove. On the stove was old food in a pot. That pot ignited. So there's a whole issue about whether the knobs on the stoves should be able for a 3-year-old to be able to turn them on. They need more pressure. There actually have been instances in Connecticut and in Massachusetts where animals have been able to jump up because they see either a box or some food and they turn on a stove. There is an aftermarket product.
Let's take a look at that.
Which is called child safety. These are child safety locks. So what parents can do, and we've actually asked that there be legislation introduced that landlords be required to give them these locks, because this is cost a grand total of $2. So what happens with these locks is you can pull off the knobs to the stove and put these on. And it locks that only an adult can unlock it, so that a child or an animal would not be able to have the pressure to turn on the stove. So clearly that's way to prevent fires.
Now, as a trial attorney, as you well know, there's an issue of notice or ability to prove that, let's say, a landlord knew or should have known that a condition was preventable. With respect to, let's just start with the stove itself. If they knew that, children go in there and they've been using this particular stove, or the stove itself has cracks or issues with it, is that considered to be some type of notice as well?
Sure, because if the stove is old and over time, the ability to turn it on, you don't need as much pressure, as much force, the landlord has to change the stove.
And how do you find out? How do you find out whether the stove, not just this stove, but any of the stoves throughout the building have had any type of issues?
Well, as I said, I've been at the building 2 or 3 times, and I tested virtually every knob. And if you can turn on the stove without applying inward pressure, that's a reason to change it. You have to be able to push in to turn the flame on. If you can just turn it without applying inward pressure, that's an indication that there's something wrong with the stove that needs to be changed.
By the way, let's take a look at this stove. If you
Sure.
if you could show the viewers the stove
Sure.
here.
So this is the stove from the fire.
Okay.
And you can see that the knob is turned. If a 3-year-old is able to exert enough pressure to turn this on,
Yeah.
that's a problem.
That's an issue.
Right. So if you have in your home, if you have a stove that doesn't take much to turn on, if it's old, if it's got grease in it over years of being in the apartment, then you should contact your landlord and say, I want my stove changed.
Which brings me very quickly to the issue of smoke alarms in an apartment. Mandatory, not mandatory? What's going on there?
It is absolutely mandatory in multiple dwellings. The landlord has to put it in. You have to reimburse the landlord, giving them back $25. In this particular building, in 2363, some of the smoke alarms worked and some of the smoke alarms did not work. The ones specifically which could have saved more lives were smoke detectors in the hallways. That's an important factor. If you don't see a smoke detector in the hallway, because it's not mandatory in the hallways, it's mandatory in the apartments, but not necessarily the hallways. But it certainly would be beneficial for people, because if they had heard the smoke detector, there may not be smoke in their apartment, but there may be smoke in the hallway that causes the alarm to go off.
Can you ask the landlord to put it in?
You should demand that the
Demand it.
landlord put it in.
Okay. Quickly, other than that tip, any other tips you want to give to somebody who's watching right
Well,
now?
you have to make sure that your door is self-locking.
Self-locking.
Because it may not be your apartment, but it may save lives in the building. You have to make sure that. Also, you should know where your fire escape is and know how to get out. I had many people in that building that had fire escapes that were blocked by couches, fire escapes that were blocked by TV stands. So when the fire occurred and they couldn't go through their front door, they ran to the fire escape, but there was stuff
just couldn't get out.
blocking. They couldn't get out.
But the landlord is also responsible, I assume, to make sure that the fire escape is accessible too. Am I correct?
Absolutely. Now, what happened in this particular fire, again, is that there were so many people on the fire escape trying to get down, and because of rust and because of time, the ladder to get down was extremely difficult to be released.
Wow.
So all of these people were on the fire escape trying to get out and trying to get down, and they were all yelling because the ladder would not get all the way released to the ground.
Well, by the way, where do we find you? Quickly, where do we get you?
www.ronville.com, or my office number 212-779-7070.
And Robert, you're going to come back and let us know how the case progresses.
I'm happy to do that. Dave.
Wonderful. All right, well, we have to take a quick break, but don't worry, we'll be back with more to today's verdict right after this.
And I can't change, even if I try, even if I wanted to. My love, she keeps me warm. 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 She keeps me warm.
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
Love is kind. Love is patient.
They said I have troll teeth.
That my voice sounded like a possessed baby doll.
That no one would ever love someone as stupid as me.
That I was fat, ugly,
Disgusting.
The effect of bullying is potent.
We will no longer be the silent majority.
Now, when you see online bullying, there's something you can do about it.
We're gonna take action with the I.
I am a witness.
I am a witness.
I am a witness.
I am a witness.
I am a witness, and so are you.
Welcome back to today's verdict. I'm your host, David Lesch. We are always encouraging you to stay connected. Tweet us at today's verdict. The Health Insurance Portability and Accountability Act deals with different aspects of health insurance coverage, standards, and plan specifications, commonly known as HIPAA. The act protects your medical history from landing in the wrong hands. Well, let's learn more with attorneys Stefan Einacone and Donna Cook. Am I saying it correct, by the way?
Stephen.
Stephen. Stephen. Of course, I got the last name right. All right, Donna, let's start off with, either one doesn't matter. Let's start off with HIPAA itself. What do we mean when we say HIPAA?
Well, HIPAA is a federal regulation that, among other things and many things, more importantly, protects your rights to privacy from your medically privileged information getting into anyone's hands, really.
All right, the history of this act based in 1996, so we're a long time past at this point. All right, am I correct?
You are correct.
But unfortunately, just because you're giving your right to medical information doesn't mean that they get the kitchen sink. Am I correct?
That's correct.
All right. So let's talk about what's most important to the viewers and certainly to me as well, is the releasing of some embarrassing things, or whether about your psychiatric treatment or issues about HIV, commonly known as there's a box called 9A. Am I correct?
Correct.
Tell the viewers a little bit about 9A.
Box 9A is just a portion of the HIPAA authorization. So in order to give someone permission to get your medical records, you have to sign the HIPAA authorization. And in order to give them information about alcohol or drug-related treatment, mental health-related treatment, or HIV/AIDS information, you have to not only sign that authorization, you have to initial box 9A in each one of those specific.
Okay. Now, Donna, you come from a defendant background.
Yes.
In other words, you're coming from the insurance company's point of view if an action is being brought. Why do you want this box initialized? What are you getting from this box?
From the defense point of view, in order to defend a personal injury action, we need the medical records to assess the diagnosis and the treatment for the personal injuries. We need to see their history, we need to see what treatment they're receiving, what their residuals are from the accident. The problem that we have with the HIPAA authorizations is a lot of facilities more recently have been rejecting our requests for medical records, which we're entitled to with a signed HIPAA authorization from the plaintiff if section box 9A is not initialed. So what happens is that we then cannot get those necessary records to defend the case.
Okay, so from what I understand, and tell me if I'm wrong, if you put your medical condition in issue, and certainly it's your emotional state, and you have had psychiatric treatment, and maybe your HIV treatment or something affects your medical condition, you say you're entitled. Am I correct?
Yes.
All right. So, but it's not so easy.
It's not so easy.
All right. Tell me why it's not so easy.
So, it's not so easy because of the privacy considerations from the plaintiff's point of view. Oftentimes they will appeal to the court. There'll be a motion that we will move to compel for this authorization to release those specific entries on the HIPAA authorization to be initialed so that we can get all of the records. Plaintiff's counsel is going to cross-move for a protective order, preventing us from getting that authorization.
Should you do that? Should you do that, Stephen? Should you, if they're making a motion for that relief so that they get the 9A initialized, does the burden then shift to you? Do you want to move for a protective order?
Absolutely.
Why is that?
Because you're only, as a plaintiff, you're only giving up your rights to the injuries claimed in that particular personal injury action. You're not giving up your rights to box 9A. And more specifically, even if you have an emotional distress claim, you're only giving up your right to a loss of an enjoyment of life to those specific physical injuries you claim in the lawsuit.
Let me ask you a question. Let's say you have a situation where somebody trips and falls on the street, and the defense is maintaining that, well, maybe the person was dizzy, that maybe they were supposed to take certain medication, they didn't take any medication, that's why they fell. I want you to initial 9A so I can find out all their medications from whatever. What do you say to that?
Everything in box 9A has nothing to do with the case. You absolutely do not get that.
Okay, and do they ever get it?
No. Sometimes the judge will bring it in for an inspection. So they'll look at the records and they'll see what needs to be taken out, redacted.
All right, well, Donna, what do you think on that one? When do you get it in situations like that?
So initially we would make demands for these items. If the court denied it but without prejudice, we would wait until we go through the full course of discovery. So once we do deposition testimony of all the parties, once we get all the other medical records, once we retain our own expert to review the records that we do have, to do an examination of the plaintiff, once we get some kind of evidence to back up a reason why we're then entitled to these additional records with the privacy reasons signed off on, then we would make another motion submitting a copy of our deposition transcript, the independent medical examination report, something that would connect the reason why we need these mental health records or the drug and alcohol treatment records or the HIV and AIDS treatment records to either the cause of the accident, the recovery from the injuries, or something else related to how the case is going.
Okay, let's talk about maybe a compromise, which is sometimes called an in-camera inspection. Stephen, what is an in-camera inspection?
An in-camera inspection is when the judge or the court inspects records, in this case medical records, by themselves. So they don't have the attorneys come in, they look at the records first, and they determine what's discoverable, what can be given to the defendants here. So they'll look at what's there, whether something relates to our claims, and if they think it should be available to the defendants, they'll give it to them, and they may even redact stuff.
Now, generally, from either the plaintiff side or the defendant side, is it something that you're willing to accept, or do you generally want those records in your hands without a judge telling you can or cannot have?
Well, from the defense point of view, we absolutely want them in our hands. Okay. We want to see all of the records. We want to see unredacted copies of them because ultimately we want our expert to be able to look at the thorough medical history of this patient and relate that to what's going on in the personal injury claims.
See, have there been any lawsuits with respect to, medical history that's been released that shouldn't have been released, either against Lincoln Hospital or any hospital that's not named just Lincoln, or just maybe against a physician, or for letting somebody see your medical records yet you did not give them authorization?
There have.
Okay.
I don't have any specific for you right now, but there have been, because that's something that's taken very seriously, and that this is on a federal level.
Okay, which is more the reason why you have to be very careful in terms of allowing the initialization. And by the way, you don't initial it, do you, as an attorney? Or does the client initial it? Who initials it?
You cannot initial it as an attorney.
Okay, so the client has to initial it.
Unless there's a power of attorney. In some circumstances, I have seen plaintiffs' counsel obtain a power of attorney from their client and then use that to sign away the HIPAA authorizations and initial what's necessary.
So best advice to a plaintiff's attorney who's watching now with respect to 9A, what do you say?
Absolutely not.
Just don't.
Don't do it, and wait for the motion to come and then make a motion to preclude.
And defense counsel?
I would say move to compel, request an in-camera inspection as an alternate avenue, and if it is denied, make that motion to compel again, post the remaining discovery so that you have a better evidence to get those
and
authorizations.
Donna, where do we find you?
So my firm is Wilson Bave Conboy Cos & Cousins. The website's wbccc.com.
And where do we find you?
SANDBLAW.com, and my office number is 718-828-8200.
And that's all we have for tonight. Wonderful guest. Thanks for joining us.
Thank you.
If you have any questions or any issues you'd like to join us in today's verdict, email me at davidlesch@bronxnet.org. And if you missed any part of today's show, be sure to check it out at www.bronxnet.tv. Also remember, if there's a legal issue or topic you'd like to see on a future edition of today's verdict, feel free to contact me. Remember, always know your law, reach a verdict,